Welcome to this edition of NYSE Governance Services Inside Compliance. I'm Erica Salmon-Byrne, Executive Vice President of Compliance and Governance Solutions at NYSE Governance Services Corpedia, and we've got a great show today. Today is our anti-corruption update, and we're thrilled to welcome to the studio John Cunningham with Baker & McKenzie. John is a partner with the firm's Investigations and Business Crimes, Corporate Compliance, and White-Collar Defense Practices, based in D.C. Prior to joining Baker, John served as a senior trial attorney with the DOJ and worked as an investigative analyst for the FBI. John, thank you for being with us.
It is a pleasure to be here, Erica. Thanks for having us.
So, as I mentioned during the little intro I just did, today's topic is anti-corruption, and there's never been a better time to talk about anti-corruption. It's obviously a tremendously hot-button issue right now. We're seeing all kinds of legislative and regulatory activity in this particular area, and companies are really asking, what do I need to be doing to prepare for this?
Exactly.
So, we're going to spend a little time today talking about Brazil, talking about the UK, talking about sort of a whole variety of things that are happening in this particular area. But let's really start with Brazil, because that's, of course, one of the most recent things we've seen happening in this particular area. The Brazilian government just passed the Clean Companies Act a couple of weeks ago. We've been talking to a lot of companies about it, talking to a lot of experts about it, and I've heard a lot of people describe it as a game changer. Would you agree with that characterization?
I do, Erica. I agree it's a game changer. I think the international community has been looking for a strong Western Hemisphere country like Brazil in the Latin American area to sort of step up on this, and the fact that now they have moved forward so aggressively, put together the law. It's a good law. It's based on the UK Bribery Act. It's based on some of the fundamentals of the FCPA. They sort of put all of that together. They're now planning on rolling out regulations to sort of help everybody understand what the meaning behind the law is and how we're going to comply. And so I think game changer is just the right nomenclature for this type of move.
Yeah, let's unpack some of that a little bit, because I think it's important for our audience to understand time-wise sort of where this all fits in the spectrum. Obviously, we saw a lot of political or public unrest rather over the course of the last couple months.
Right.
We've got, we're leading up to the Olympics in Brazil. We're leading up to the World Cup in Brazil. There's a lot of opportunities, public procurement project-wise, for money to change hands. And you mentioned regulations are coming. So there's a lot that we still don't know about this law, right?
Absolutely. And I think, clients, we're getting a lot of questions from clients about, well, tell us, is this following the track of the UK Bribery Act? Are we going to hear a lot of information and then sort of need to back off and wait? Or should we be planning things now? And I think, South America is a lot different than Europe, which is a lot different than Asia. And so you need to consider South America. And now that we've got Brazil moving forward with this type of legislation and, like you said, regulations coming in close behind, I think it is time to start thinking about compliance in South America and compliance in Brazil, because my best guess is that more countries in the area are going to start to follow this model now with Brazil.
And so just to sort of set the floor for our audience, we're still waiting to hear what a good compliance program looks like for credit under the Clean Companies Act.
Correct.
We still have some unanswered questions about extraterritoriality, right?
True.
In terms of how are we going to calculate the fine size? Is it going to be based on the Brazilian subs revenues, or is it going to be based on the parent company's revenues? What if you're a UK-based company with operations in Brazil and somebody bribes someone in Russia? Are you going to have a Brazilian issue as well as a UK issue, as well as, hypothetically at least, a Russia issue? And we don't know the answers to those questions yet.
Yeah.
So how are you advising your clients with so much still out there that we have questions about?
Yeah, it's a really fair point, Erica, and I think one of the things we're doing to try and help clients wrap their heads around this is to say, well, look, Brazil more likely than not is going to follow the leaders in this area, and that's the U.S. and that's the United Kingdom, and we have the benefit of really strong FCPA guidance. We have the benefit of really strong UK Bribery Act guidance, and so I think from a best practices perspective, we can take those as a whole, sort of apply them to what's happening in Brazil and say, well, we know these things work at the highest bars with the UK and the U.S. More likely than not, they're going to work with Brazil. So let's start there, and then we'll see how the regulators filter things down.
Right, and that's exactly what we've been talking about with our clients as well, and especially since there's no indication the Brazilians want to reinvent the wheel. Right. I mean, you've got the OECD Good Practice Guidance, you've got the UK Bribery Act Guidance, you've got the FCPA Resource Guide. Those are all really great sources for what a good compliance program looks like. They're going to help you mitigate your risk every place else, so there's no real reason to think they're not going to work in Brazil, with one notable exception, and that's facilitation payments.
Good point.
So, you know, obviously the U.S. still has this exception. It lives out there, but the Brazilian legislation doesn't have it. The OECD convention doesn't have it. The UK Bribery Act doesn't have it. Every indication is that the new Colombian legislation won't have it. So where does that leave the U.S. and, more importantly, where does that leave a multinational company that's based in the U.S. that has been relying on that exception?
It's a great point. And, you know, I think where it leaves the U.S., and we've gleaned a lot of the advice that we're now providing to our clients about facilitation payments from the guidance, because the guidance in a lot of ways, and I'm talking about the FCPA guidance that came out in November 2012, has backed off with respect to the exception for facilitation payments to the FCPA. And what they've said essentially is we've never come out and endorsed this. On the other hand, it's there, and it's built into the statute, but it's probably not something we think is a great idea. Now, I'm paraphrasing, of course, for the government. And so I think the U.S. is slowly sort of receding their own tide on facilitation payments to the point where, and you and I had discussed this earlier, but most companies are now saying, you know what, it's probably not the best idea to include this, because we can't really tell what the U.S. is saying. It's a very difficult thing to determine between what's discretionary and non-discretionary in terms of the type of activity the government officials involved in. So best practice, in theory now, would probably be, given the UK Bribery Act, given the Brazilian law, given other laws, given the OECD, probably not to have those unless it's an absolute business necessity. And in those cases, you need to have a whole bunch of compliance safeguards in place.
Yeah, and that's exactly that's completely consistent with what we're seeing our clients do. Completely consistent with what we're seeing companies do from a survey perspective. You know, when we collect benchmarking data, we're seeing somewhere between in our own client base, it's about 50%. In the survey data, it's about 70% of companies that are saying, you know what, we just don't have a facilitation payments exception any longer. We get a question a lot that you and I were chatting about, and I just want to go ahead and put it on video for our audience, and that is, well, what if it's a health and safety exception? And as I always say to clients, you know, when they raise that concern, that's not a facilitation payment. A facilitation payment is something you're paying to the government official to expedite something that is a routine governmental action to which you would otherwise be entitled. Somebody's got a gun to your head at a checkpoint, that's extortion. You know, it's a completely different thing altogether. Right,
and you're right, Erica, because the process that you're speeding up is the continuation of your life, essentially, right? So that has nothing at all to do with getting something through customs or otherwise. So extortion and duress, a whole different ballgame from facilitation payments. We still get a lot of pressure for clients. They say, well, gosh, we don't want to have facilitating payments, but we're worried about this whole notion of people getting in trouble. And so we explain that, well, if your policy is built, if you have something in your policy that demonstrates that you there are situations where the health or safety or one of your employees, there's a duress situation, there's extortion, that's going to fall outside of your policy anyway. And so you don't even need to include that within the bailiwick of facilitation payments. You can take that outside and make an exception for people who are trying to save their lives.
Yeah, exactly. Just be sure to record it appropriately on your books and
record. Yeah, good point.
So I want to switch gears and talk a little bit about the UK Bribery Act. Because this past week, you know, we just saw the first defendants appear in court under Bribery Act charges, and there's been a lot of noise about the lack of enforcement of the Bribery Act, and you know, the thousands of pages that the SFO just admitted they had lost for, you know, the BAE case. What do you think is happening in the UK, and do you see this as sort of the first baby step towards something more significant?
Well, I do. I think David Green, the new SFO director, has sort of made a sea change in that he has decided now this is the time where all of the eyes around the world are on us in terms of enforcement. The UK is seen as a leader in business and other things, but for some reason they sort of slagged behind in terms of anti-corruption enforcement. David, it seems like Mr. Green has really taken it upon himself to prioritize this, and in the past 6 months what we have seen are a buildup of the number of prosecutors at SFO. We've seen a buildup in financing and resources coming from Parliament. These little signs that happened about 5 or 6 years ago with the U.S. enforcement agencies are starting to happen with the UK. And now you've got 3 defendants who were just in court last week, actually, on the UK Bribery Act. And so you're starting to see the first signs of the efforts behind the scenes to get the Serious Fraud Office up and going on on anti-corruption enforcement. And so that's a really good development for them, because I think it's an unfair comparison to go FCPA, wow, lots of enforcement, big guns, and then UK Bribery Act. What's going on here, guys? It's been 3 years. Well, the difference, it's been 35 years to the FCPA.
Exactly.
So 3 years and 35 years, not really a good apples and apples to apples comparison.
Right. Yeah. I mean, if they had their first major corporate prosecution in 2030, they'd be ahead of where the U.S. was.
That's exactly right.
With regard to the FCPA.
Good point.
And what about the new DPA guidance that came out of the UK? I mean, there's no doubt, and this is certainly, you can put a positive spin on this or you can put a negative spin on this, but deferred prosecution agreements and non-prosecution agreements have really been the way that corporations, at least, are charged here in the States from an anti-corruption perspective. Do you see this DPA guidance coming out of the UK as a sign that there's corporate stuff coming?
I think so. I think it's, again, David Green, the fact that this is all happening under David Green's watch doesn't surprise me, because I think he, again, has said, now is the time, the iron is hot, let's strike it. And so DPAs, as we know, will offer, in theory at least, the opportunity to speed these investigations up. And also, frankly, give corporations the chance to not necessarily have to smear themselves going through the press and these elongated trials and things like that. It's a really nice way to make things happen a lot quicker on the UK side. And so I think the UK is viewing it like that. The issue, I guess, with them is that there's much more judicial oversight of these sorts of things, even built into the current guides on what's going to happen with DPAs.
Yep.
So whether it works in practice like it does with the Department of Justice, we'll have to see.
Yeah.
But one can hope.
Right. We could have a lot of situations like the SEC settlement with was it Citibank, where the judge said absolutely not. This is
could happen.
Could happen.
Yep. Yeah. Judicial oversight. Who knows? Judges are going to make up their own minds on those things, and it wouldn't be anything like the U.S. where judges are apt to be more deferential to prosecutors.
Right.
Yep.
Yeah. So it'll be really interesting to see what happens. But certainly, we can say with a fair amount of comfort that if you are a company with significant exposure in the UK, it would behoove you to make sure that your house is in order, because there's every indication that serious frauds is serious.
I think that's right, and we recently wrote about this. We called it the signs of spring at the SFO, and this was back in the spring. It does seem like there's a renewed commitment here, and I'm sort of giving David Green credit for all that. It's possible that his predecessor was involved in that too, but whatever the case, the UK does not want to be seen as lagging behind the US in this capacity, because they see themselves as a world leader, and they see themselves taking anti-corruption very, very seriously. They want it to be US and UK up here, and everybody else looking to them for guidance on how to go forward on anti-corruption.
Right. Right. No, that makes a lot of sense. And speaking about everybody else, we're moving into the end of the year. We're not quite there yet, thankfully, but we're headed in that general direction. And so, people are going to start prognosticating about 2014 and what to start thinking about for next year. Obviously, Colombia's on the horizon. We've got increased regulatory enforcement activity in China. Canada has their first corruption investigation.
Yep.
What are you keeping your eye on for 2014? What do you sort of see as the next likely place to?
So a lot of the multinationals functioning out of the United States have talked a lot about Canada, and so we actually are keeping an eye on Canada here because of the recent uptick in enforcement. And I think this is great that you brought that up, Erica, because I do think Canada is, like the UK and like Brazil, trying to get there where they think they should be, getting pressure also from their own public to get, to meet those standards. And should our companies be held to a different standard than U.S. companies? Probably not. Right. From a U.S. perspective, it's nice also, right, because now other countries like Canada, where a lot of multinationals are functioning out of the U.S. and Canada, it's nice to know that companies will be held to a same standard, even if they're based in Canada, for those companies based in the United States. I think a lot of the complaining about the FCPA is the fact that, look, we're held to a different standard than the rest of the world. Right. The fact that places like Canada, Brazil, Germany, you mentioned Colombia, are starting to catch up, I think, is good for this equity argument about all companies being created equal, irrespective of where their jurisdiction, their mainframe jurisdiction is. Right.
So, I mean, just considering that list of countries that we just came up with, maybe for 2014 we should really just go see who the OECD is picking on.
That's right. That does seem to be the trend.
It does really seem to be the trend. The OECD gives pressure, puts a tremendous amount of pressure on Britain. Results in the UK Bribery Act, tremendous amount of pressure on Brazil, tremendous amount of pressure on Canada. So, I think we should probably just go take a look at at who they're shaming
That's
at
a good
this
point.
point.
And you mentioned Colombia too,
Colombia.
right? So recent there too,
Yep.
and now sure enough they've got new legislation.
Right.
And so the OECD, and kudos to them for tracking this so closely. And frankly, my understanding, based on what I've seen in the literature and in commentary and enforcement actions, is that the U.S. government is closely tracking a lot of the framework of the OECD. So everybody's slowly starting to get aligned. It's just taking time. It's like sort of we're not at the critical mass point, but we're edging there.
Yeah, we're headed in that general direction.
Yeah.
You know, one of the things that we often talk to our clients about is the size and scope of their ethics and compliance program, and we saw some great language coming out of the FCPA Resource Guide last fall. Of course, we're coming up on the one-year anniversary of that, specifically in Chapter 5 related to mapping your compliance program to risk, right? So what does your risk profile look like? What does your particular company need? And really making sure that you're closely tracking everything you're doing to what your particular risk profile is.
Right.
And we all know, you know, that there's no doubt that the companies that have had issues are the companies with the very best programs.
Yes.
So what are a couple of best practices of your clients that you would say, you know what, I really want to get these out there and make other ethics and compliance practitioners aware of them?
You know, our most stringent compliance clients have really honed in on this notion of third parties, because it seems to me, and I don't quote me on this, but one of the recent statistics I saw on third-party involvement in FCPA enforcement actions was up around 70–80%.
It's a little higher than that.
It's even higher than that, right? And Erica would know from being from Corpita better than I would. So 70, 80, maybe even 90% involving third parties. So in terms of the best practice thing that I've seen, that sort of I've looked back and said, wow, I'm really impressed with this. And of course, we've helped to develop these things, but it takes company resources to get it done right. Putting together this sort of automated system where you've got a third-party due diligence system where you can function with your due diligence questionnaires, your business sponsor forms, and your other inputs that go into the system. Everything is done through an automated third-party vendor. Right. I won't name any here, but I'm sure you know all too many of them. And having that automation done where there's risk scoring, professional risk scoring by an objective vendor, and you've got people who are dedicated to this, to getting the work done internally at the company, and at the end of the day you get this automated, healthy output, but with a subjective oversight from your compliance experts. That's the thing that impresses me most in terms of what's happening on the third-party front. And frankly, third party seems to be the greatest FCPA risk right now. So third-party programs that are using this automation, using it right, but also making sure they're resourced internally properly to give that subjective perspective.
And making sure that those third-party systems are being changed to take into consideration what's happening in the universe. Because, you know, I mean, a couple of years ago, nobody would have put a customs clearance vendor like Panalpina on their high-risk list, but obviously that was incorrect. And now, hopefully, anybody who's operating in China has put their travel agencies at their highest level risk ranking in terms of you know, the due diligence that they're doing. And we saw some of this in the resource guide too. You know, you need to think about, are you going to offer your FCPA training or an abridged version of it to your third parties? Are you going to have a third-party code of conduct? So those are all things to start thinking about as far as your anti-corruption program is concerned.
So true. And I think you raised the issue of China, and I think obviously this is a really hot spot right now in anti-corruption enforcement, but looking to distributors and travel agencies and those vendors that may not have gotten that type of scrutiny in the past is going to become more important. And then you have companies coming back and saying, well, geez, Erica, how am I going to do all of this, right? But it goes back to your original point. It's based on risk. Is your risk distributors in China in the pharmaceutical industry? If it is, then you should be paying more attention there. And perhaps you don't need to be paying as much attention necessarily to certain suppliers or other third-party vendors. But distributors, yes. And so assessing that risk on the front end, the most critical part of getting a hold of what you should be doing in terms of compliance.
At the end of the day, it's just not one size fits all. It really can't be.
It's not.
Well, John, we are unfortunately out of time for today, but this was
so much fun.
A fantastic update, and thank you so much for joining us. We'd love to have you come back at some other time and spend a little bit more time talking about anti-corruption.
I really appreciate it.
And thank you, thank you again. So, and thank you to all of you who joined us for this edition of Inside Compliance. We hope you enjoyed the show and that you'll join us again next time when we discuss another interesting and important topic in the ethics and compliance arena.